Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On the 9th of October 2024, the state of Idaho in the Idaho 4 case filed state's objection to defendant's motion to trifurcate. That means to make 3 proceedings and apply rules of evidence during eligibility phase. So again, this filing is responding to the defendant's motion regarding trifurcation of proceedings, which the defense filed on September 5th, 2024. It begins by stating, under the analysis section, page 1, in his motion, defendant disregards applicable statutory authority and binding appellate decisions, and instead makes a public policy argument that this court should do 2 things. First, he asks the court to disregard the language of Idaho Code Section 19-2515, which sets forth a 2-part, we go on to page 2, a 2-part jury proceeding in capital cases. Under the defendant's proposed scheme, the trial would not be composed of a culpability phase and a sentencing phase as set forth by statute, but would instead be split into 3 proceedings for culpability, eligibility, and punishment. So in summary, what the state appears to be arguing here is that while the statute cited allows for 2 separate proceedings in a case, culpability and punishment, culpability, that's the case in chief. That is where the state would be required to persuade a jury that Mr. Kohberger is guilty beyond a reasonable doubt of the 5 felonies he has been charged with in the indictment. And of course, the standard at this time under the law is that he is presumed innocent. So again, what the state is saying is that rather than 2 proceedings, culpability phase and a sentencing phase, that Mr. Kohberger is arguing a public policy issue. And we've seen this before in other responses where the state is saying he's arguing public policy. He's not basing his motion on a statute as applied to appellate rulings. And instead, once this new issue, 3 proceedings, culpability, that's the case in chief, eligibility, that is for the death penalty, and then punishment, whether or not he should get the death penalty. Goes on to say, next defendant asked the court to disregard long settled precedent holding that the Idaho rules of evidence do not apply to sentencing proceedings and apply them anyway. The court should decline to do either. Then goes on, page 2, to discuss Idaho Code 19-2515, which provides for a single sentencing proceeding. So that means if a defendant is found guilty, then you move into a single sentencing proceeding as to whether or not capital punishment is what is appropriate or if it should be something like years in state prison. If you would like to review this document, please follow the link that I have provided in the description to this episode. And as always, thank you very much for joining us here today.